Mojo Mathers.
I'm extremely pleased that finally this bill is coming before the House. It's a bill that's long overdue to modernise consumer protection law in New Zealand, and it would be fantastic if it could get passed before Christmas, especially when so much spending is going on in New Zealand. The Green Party is particularly pleased to see the unsubstantiated representation clause in the bill. At the moment, we have lots of products that are increasingly trying to jump on the greenwash bandwagon and make claims, all sorts of claims about how they'll be clean and green, reduce the impact on the environment, be environmentally responsible, and so on. And by and large, consumers are very trusting. So if a company makes that claim about their product, then consumers will often believe that that is the case, that that product is better than other products on the market and will have a lower environmental footprint, and therefore, if they care about these issues, which many do, they will choose to buy that product. And it's extremely difficult to prove that they are making a false claim. It can be costly and ineffective, and so not many of these products get actually taken to task for making such a claim, even though they are profiting from making these claims, especially when they're unsubstantiated. So it's fantastic to see that the bill has a clause that will finally address this by placing the onus of proof on the company making the claim that they have some evidence to back that claim that they're making. And it's a very simple, straightforward expectation, is that you don't make a claim unless you actually have some evidence for that claim. And Consumer New Zealand gave a very powerful submission to the Select Committee, and they gave they test a lot of products for their claims, and they gave the example of a vacuum cleaner system where a $3,000 vacuum cleaner that advertised itself as a world-class indoor environment management system that reduced asthma and allergy. And when they actually tested it, they found that it performed no better than the $100 product on the market. So people were paying basically $2,900 more for a product on the basis of its claim that were found to be unsubstantiated and untrue. And this is the kind of thing that we don't want to see happening. It puts honest traders, honest companies at a severe disadvantage. And it's fantastic that finally we have a law that places the onus of proof to back the claim onto the companies making the claim. Now, it's quite extraordinary at the Select Committee to see the number of large companies submitting against this. We came under a lot of pressure. Power companies, wine-growing companies, all sorts. They say, no, don't make us prove that our claims are actually based in fact. And I just found that quite... I want to congratulate the Select Committee members for withstanding that very obvious hypocrisy and staying staunch on the side of consumers and consumers' right to be protected and retaining that clause. However, the Select Committee did recognise that there was a case to, for some time, claims were made that were so fanciful that they were obviously untrue, and that this was just a sort of marketing ploy that could be used to say, oh, if you consume this product, it will make you a superhero or something like that. And so we've been suggested a clause in the bill that allows sort of obvious, exaggerated claims to be continued to be made. There was a... we're also very glad that the Commerce Committee had got, Commission has got additional power to enforce notices and investigation powers. One of the concerns that I did have after the Select Committee stage was that there was no clause in the bill to allow substantiation notices. Can I continue the call?
Yes, Mojo Mathers. You need to call. That's right.
To continue the substantiation notices such as they have in Australia, and so we wrote to the Commerce Commission to ask if they would find the having power to issue substantiation notices helpful in enforcing the clause around unsubstantiated representation. And they wrote back saying that they had originally sought these provisions, but they now think that the substantiation provisions in this bill are actually going to be workable because they're simpler, because they're more easily enforceable, and that they provide a better education tool. And so they are confident that they have sufficient powers under this new Act as it stands, particularly in conjunction with the information gathering powers that they have. So because of this letter from the Commerce Commission, we are hopeful that this bill will work as intended and that they do have the power to enforce unsubstantiated representation effectively. The other part of the bill that we're incredibly pleased to see is the fact that for the first time online traders will be required to identify themselves as such. In the past, very often if you were on a auction site, such as Trade Me or so on, it was not always clear whether the person selling the product was in trade or not. And of course, it is only when someone is in trade that the protections of the Consumer Guarantees Act comes into play. So it's incredibly important that from the consumer perspective, they don't know when someone is in trade, when they're purchasing something from someone that's in trade. Again, this was a clause that was strongly resisted by a lot of groups and auctioneers in particular, traders who use online websites for auction. And I'm very pleased to see that this has been retained because people do not realise the difference when they're going online. So it's fantastic to see that now consumers are going to be properly protected wherever they're purchasing from a trader, whether that's online or offline, at any different kind of venue. They will be protected under the Consumer Guarantees Act. And that is a great move forward.
Sorry. Dr. David Clark.
Thank you, Mr. Chair. I rise to speak